Good morning, class. My name is DEEPAK, 10th of JAYOTI VIDHYAPEETH Women's University, and in today's class, we'll see in Central Sales Tax, we will see how we'll register our dealers, right? How to make registration of dealers. So every dealer liable to pay tax under this Act, under CST Act, shall within such time as may be he prescribed for the purpose make an application for the registration under this Act to such authority in the appropriate state as the central government may, by general or special order. Specify when such application shall contain such particulars as may be prescribed. Any other liable to pay tax under the sales tax law of the appropriate state or where there is so much law enforced in the appropriate state or any part thereof. Any dealer having a place of business in that state of part as the case may be made, notwithstanding that he is not liable to pay tax under this Act. Apply for registration under the Act to authority referred to in the subsection, and every such application shall contain such particulars as may be prescribed. For the purpose of subsection, a dealer shall be deemed to be liable to pay tax under the sales tax law in the appropriate state, notwithstanding that under such law a sale or purchase made by him is exempt from tax or refund or rebate taxes admissible in respect thereof. So, where the appears necessary to authority to whom an application is made under subsection 1, subsection 2, so to do for the purpose realization of the tax payable under this Act or for the proper custody and use of forms referred to the subsection 1 of subsection 6a or of subsection 8. He may be an order in writing and for reasons to be recorded therein and impose a condition for the issue of certificates of registration, a requirement that the dealer shall furnish in the prescribed manner and within such time as may be specified in the order such security as may be so specified for all or any of the aforesaid purpose. If the authority to whom an application under subsection or subsection 2 is made is satisfied, then the application is in conformity with the provisions of this Act and the rules made and then the rules made uh, there under if any imposed under subsection 2a has been incomplied, he shall register the applicant and then grant to him a certificate of registration in the prescribed form, of which shall specify the class or classes of goods for the purpose of subsection 1 of section A. Now we'll see what is the appears, where it is appears necessary to authority granting the certificate. Right, so of registration under this section, so to do the proper realization of tax payable under the Act for the proper custody and use of forms referred to subsection 3a. He may anytime while such certificate is enforced by an order in writing and for reasons to be recorded therein, require the dealer to whom the certificate has been granted to furnish within such time as may be specified in the order in the prescribed manner such security, or if the dealer has already furnished any security in pursuance of any order under the subsection or subsection 2a, such additional security as may be specified in the order for all any of the aforesaid purposes. Now, no dealer shall be required to furnish any security and subsection 2a or any security or additional security under subsection unless he has given an opportunity of being heard. The amount of security which a dealer may be required to furnish under subsection 2A or subsection 3A are the aggregate of the amount of such security and the amount of additional security which he may be required to furnish under subsection 3A by the authority referred to therein shall not exceed. In the case of a dealer other than a dealer who has made an application or who has been registered in pursuance of an application. Under Section 2, a sum equal to the tax payable under this Act, in accordance with the estimate of such authority on the turnover of such dealer for the year in which such security or as the case may be, additional security is required to be furnished and in the case of dealer who has made an application or who has been registered in pursuance of an application under subsection 2, a sum equal to tax receivable under this Act, in accordance with the estimate such authority on the sales to such dealer in the course of interstate trade or commerce in the year in which such security as the case may be additional security is required to be furnished, has such dealer been not be registered under this Act. So where the security furnished by a dealer under subsection 2A or subsection 3A is in the form of surety bond and the surety becomes insolvent or dies, the dealer shall within 30 days of the occurrence of any of the aforesaid event inform the authority granting the certificate of registration and shall within 90 days of such occurrence furnish of fresh surety bond or flourish in a prescribed manner other security for the other amount to be borne. So the authority granting the certificate of registration may be ordered and for good and sufficient cause forfeit the whole or any part of security furnished by a dealer for realizing any amount of tax or penalty payable by the dealer. And if the dealer is found to have misused any of the forms referred in subsection 2A to have failed to keep them in a proper custody. Now, where by reason or an order, subsection 3D, the security furnished by a dealer is rendered insufficient. He shall make the deficiency in such manner within such time as may be prescribed. The authority issuing the forms referred in subsection may refuse issue such forms to a dealer who has failed to comply with an order under this subcaution or subcaution 3A or with the provision of subsection C. The subsection until the dealer has complied with such order or such provision. As the case may be, the authority granting a certificate of registration may, on application by the dealer to whom it has granted, order the refund of any amount or part thereof deposited by the dealer by way of security under the section. If it is not required for the purpose of act, any person aggrieved by an order passed under subsection 2A. Subsection 3A, subsection 3D, or subsection 3G may within 30 days of the service the order on him, but after furnishing the security prefer in such form and manner as may be prescribed. An appeal against such order to such authority hereafter this section refer to the appellate authority as may be prescribed. Prescribed that appellate authority may be sufficient cause permit such person to present the appeal. After the expiry of said period of 30 days or without furnishing the whole or any part of such security, the procedure to be followed in hearing any appeal under subsection and the fees payable in respect of such appeals shall be such as may be prescribed. The order passed by the appellate authority in any appeal under subsection 3G shall be final. The next is the certificate of registration granted. This section either on the application of the dealer to whom it has been granted or where no such application has been made after due notice to the dealer, the amendment by the authority, granting it if he is satisfied that by reason of registered dealer having changed the name, place, or nature of his business or the class of business or goods in which he carries on business or for any other reason the certificate of registration granted to him requires to be amendment or be cancelled by the authority granting if where he is satisfied after due notice to the dealer whom it has been granted that he has caused he has ceased to carry on business or has ceased to exist or has failed without sufficient cause to comply with an order under subsection 3A or with the provisions of subsection 3C or subsection 3E or has failed to pay any tax penalty payable under this act or the C and or the case of a dealer registered under subsection 2 he ceased to be liable to pay tax under the sales tax law of the appropriate state for any other sufficient reason. A registered dealer may apply in the prescribed manner not less than 6 months before the end of the year to authority which granted his certificate and registration for the cancellation of such registration, and the authority shall, unless the dealer is liable to pay tax under the Act, cancel the registration accordingly, and where he does so, the cancellation shall take effect from the end of the year. So that's all for the registration of dealers. I hope you understood the session. If you have any type of doubt, you can ask your doubts in comment box. I'll definitely clarify your all doubt in next class. And if you like this video, please share this video with your friends. And if any doubt, then please tell me. If you want to give me a suggestion, please give me suggestions also. I'll improve myself and will bring new videos with your suggestions. Thank you very much. Have a nice day. Question they can ask in this is what is the what is the procedure of registration of dealers? One question they can ask you, then they can ask you what forms they can use in central sales tax. Then they can ask you is that necessary to do registration in central sales tax and what is the tax rate of central sales tax. All these questions they can ask in competitive exams. So thank you very much. Have a nice day.